5 seconds to go. Start. Other interlocutory judgments which are a step towards the decision of the dispute between parties by way of a decree or a final order. It is needless to point out that interlocutory orders are of various kinds. Some, like orders of stay, injunction, or receiver, are designed to preserve the status quo pending the litigation and to ensure that the parties might not be prejudiced by the normal delay which the proceedings before the court usually take. They do not, in that sense, decide in any manner the merits of the controversy in issue in the suit and do not, of course, put an end to it even in part. Such orders are certainly capable of being altered or varied by subsequent applications for the same relief, though normally only on proof of new facts or new situations which subsequently emerge, as they do not impinge upon the legal rights of parties to the litigation. The principle of res judicata does not apply to the findings on which these orders are based, though, if applications were made for relief on the same basis after the same has once been disposed of, the court would be justified in rejecting the same as an abuse of the process of court. There are other orders which are also interlocutory but would fall into a different category. The difference from the ones just now referred to lies in the fact that they are not directed to maintaining the status quo or to preserve the property pending the final adjudication, but are designed to ensure the just, smooth, orderly, and expeditious disposal of the suit. They are interlocutory in the sense that they do not decide any matter in issue arising in the suit, nor put an end to the litigation. The case of an application under Order 9, Rule 7 would be an illustration of this type. If an application made under the provisions of that rule is dismissed and an appeal were filed against the decree in the suit in which such application were made, there can be no doubt that the property of the order rejecting the reopening of the proceeding and the refusal to relegate the party to an earlier stage might be canvassed in the appeal and dealt with by the appellate court. In that sense, the refusal of the court to permit the defendant to set the cloak back does not attain finality. But what we are concerned with is slightly different, and that is whether the same court is finally bound by that order at later stages so as to preclude its being reconsidered. Even if the rule of res judicata does not apply, it would not follow that on every subsequent day on which the suit stands adjourned for further hearing, the petition could be repeated and fresh orders sought on the basis of identical facts. The principle that repeated applications based on the same facts and seeking the same reliefs might be disallowed by the court does not, however, necessarily rest on the principle of res judicata. Thus, if an application for the adjournment of a suit is rejected, a subsequent application for the same purpose, even if based on the same facts, is not barred on the application of any rule of res judicata but would be rejected for the same grounds on which the original application was refused. The principle underlying the distinction between the rule of res judicata and rejection on the ground that no new facts have been adduced to justify a different order is vital. If the principle of res judicata is applicable to the decision on a particular issue of fact, even if fresh facts were placed before the court, the bar would continue to operate and preclude a fresh investigation of the issue, whereas in the other case, on proof of fresh facts, the court would be competent and would be bound to take those into account and make an order conformably to the facts freshly brought before the court. This leads us to the consideration of the nature of the court's direction under Order 9, Rule 7, the nature of that interlocutory proceeding with a view to ascertain whether the decision of the court under that provision decides anything finally so as to constitute the bar of res judicata when dealing with an application under Order 9, Rule 13, Civil Procedure Code. To sum up the relevant facts, it is common ground that the suit 134 of 1956 had passed the stages up to Rule 51. Order 9, Rule 6 applies to a case where a plaintiff appears and the defendant does not appear when the suit is called on for hearing. Order 11, Rule 6 provides to quote the material part where the plaintiff appears and the defendant does not appear when the suit is called on for hearing, then, if it is proved that the summons was duly served, the court may proceed ex parte. Stop.